Our survey, conducted by the EIU, reveals that nearly 1/3 of businesses interviewed in the transport and shipping sector have experienced an international commercial dispute in the past 2 years. The most common cause for these disputes is breach of contract. In developed markets, 31% of all companies pointed to a contractual breach as the cause of a commercial dispute. The figure rises to 44.4% for those operating in transport and shipping sector. In breach of contract cases, we are more frequently seeing cultural differences as contributors to legal proceedings. A notable English law case revolved around whether a contract of guarantee is enforceable when it is contained not in a single document signed by the guarantor, but in a series of documents authenticated by their email signature. Golden Ocean negotiated the charter of a vessel to Salgokar, which took place primarily by email. Salgokar later denied the existence of these negotiations and the contracts. Golden Ocean brought a claim under the guarantee for $54 million, and the Court of Appeal upheld the High Court's ruling that an enforceable guarantee can be created by a series of emails authenticated by the online signature of the guarantor. This case highlights the need for companies to be more forward-thinking when it comes to assessing risk. In today's environment, it is increasingly necessary to be aware of how agreements may be entered into or interpreted in different jurisdictions. When it comes to the question of enforcement, there is often a question mark around arbitration as a route to resolution. Companies need to ensure that they are able to collect and recover, and also need to be aware of the jurisdiction in the country where their counterparty or its assets are located to make sure that it is enforcement friendly. In order to help mediate the risk of international commercial disputes, companies should consider 2 precautions. 1, always have performance guarantees in place from the major holding company, or where possible, have bank guarantees or a letter of credit to help avoid having to go through a long-winded enforcement process. 2, be cautious and do not rush into contractual commitments in countries unlikely to have the appropriate enforcement legislation in place. The biggest risk usually comes down to how you enforce your contract, so by taking the proper precautions, it should be something that can be avoided.
We are seeing a growing trend in international disputes towards big commercial cases revolving around technology and intellectual property. One of the biggest issues concerning IP today is online piracy. Our research reveals that executives believe that IP theft will become a greater challenge in BRIC and other rapid growth markets over the next 2 years. 35% of those who've been involved in a commercial dispute recently believe this issue will be the most likely cause of a commercial dispute for their organisations in these markets over the next 2 years. This is especially the case in the media and technology industry, where the digital landscape has made the ability to infringe on IP and copyright much more accessible. IP has also proved difficult for companies investing outside of Europe, as although the EU has a uniform system of protection, different countries have different territorial rules. Today, more countries are adapting their IP laws to US standards to try and protect their rights. This could, eventually, lead to internationally harmonised rules for IP protection. Where possible, organisations should always try and establish a business contract with external parties, as it will reduce the likelihood of rights infringement and subsequent commercial disputes. If there is a professional relationship in place, it's likely that all parties will want to try and maintain this to eliminate risk.